Good morning, everyone. I'd like to thank Professor Kilkelly for giving me the opportunity to speak this morning and to share my research with you. My research, as Professor Kilkelly mentioned, was conducted with a colleague in Applied Social Studies, Dr. Simone McCaughrean, who basically it's her own area of expertise will be adoption, but relating to Dr. Hanson's idea of interdisciplinarity in the context of children's rights, it's very useful to look at, I suppose, the actual practice dimension to inter-country adoption as well as the legal approach. And so Dr. Cochrane and I basically, over the course of the last year anyway, have been researching this particular area. Obviously, in January of this year, some of you might be familiar with the fact that 11 Irish couples were questioned concerning the discovery of an international child smuggling ring by Mexican police, and these children ranged from 2 months up to the age of 2 years of age. And reports at the time concerned the fact that local women had sold babies for placement through private adoption agencies in Mexico. And this is despite the fact that Mexico has been a signatory to the Hague Convention on inter-country adoption, in the same way that Ireland has been a party to the convention and has incorporated it recently through Irish law. So my paper today is focusing on the issue of inter-country adoption law as it exists within Ireland, and I suppose the challenges that have presented and will continue to present over the next few years. Okay, so just to look at the purpose of inter-country adoption, it's very important to be aware of the fact that, inter-country adoption is a mechanism designed to provide children with mother and father in a way that respects their rights, and not to enable foreign parents to satisfy their wish for a child at any price. There can be no right to a child. And I think, recent times and even over the last few decades, it's been very clear that that objective is often lost sight of, and the best interests of children are forgotten in the process of inter-country adoption. The Irish Adoption Act of 2010, which came into force in November of 2010, had four main objectives: to consolidate and repeal the existing legislation for acts which dated from 1952 to 98, the formal establishment of the Adoption Authority of Ireland as the central body for adoption in Ireland, to facilitate the recognition of bilateral agreements under Irish law, and finally then to formally incorporate the Hague Convention on inter-country adoption into Irish domestic law. Today my paper is going to address the following issues. Firstly, what is inter-country adoption? Secondly, what the pros and cons of the inter-country adoption system are. It's also going to address the international legal framework as set out both under the UN Convention on the Rights of the Child as well as under the Hague Convention on Protection of Children and Cooperation in respect of inter-country adoption. I'm then going to move on and look at inter-country adoption in Ireland, and in particular Ireland as a sending and a receiving country. And then finally, some positive developments, but highlighting the fact that some shortfalls still remain. So in terms of what exactly is inter-country adoption, well, it's a means through which a child who may possibly face an otherwise bleak future is provided with the opportunity of a loving and secure home. However, over the recent times, inter-country adoption has also been depicted as something associated with child trafficking, child farming or baby farming, kidnapping, and even mothers relinquishing their rights in relation to their children under dubious circumstances. It's also been seen as an exploitation of poor and impoverished countries by powerful nations. This exploitation is particularly visible in countries where, natural disasters or internal conflict are prevalent. One of the more controversial aspects of inter-country adoption, child trafficking, has seemed to raise its ugly head during these unsettling times. This has been witnessed time and time again, dating as far back to the 70s when thousands of children were airlifted from Vietnam to the US. Instances of this kind seem to bring about a resurgence of interest in adoption. And it's important that, for that reason, that safety procedures and mechanisms are designed to protect the needs of children and the needs of the most vulnerable, and that they're not bypassed in the process. However, it is important to remember what, I suppose, the arguments in favour of inter-country adoption are. So, for example, the fact that it's the only realistic opportunity for some children to have a secure and permanent home and family life. Some would also argue that with or without inter-country adoption, thousands of children are going to grow up in a distorted and dangerous environment anyway. But it's important not to lose sight of the fact that it is a process that's open to abuse. It can be exploitative, imperialistic and detrimental to children because they're separated from their home, society and culture. And finally then there's an argument that the corruption can, and I suppose the process itself, can divert professional resources away from children's needs. So what is the international legal framework in relation to inter-country adoption? Well, first of all, up until 1989, inter-country adoption was only regulated by bilateral agreement, or regional agreements in Northern and Western Europe and the Americas. The year 1990 witnessed the beginning of a rights-based approach towards children who are involved in the process of inter-country adoption with the UN Convention on the Rights of the Child, 1989, which under Article 21 specifically recognises inter-country adoption as a measure of last resort. However, it's important to remember that the UN Convention on the Rights of the Child has to be interpreted in a holistic manner, so therefore all the rights contained within the Convention's provisions must be looked at in a holistic way. So Article 7 in relation to the fact that a child has a right to be known and cared for by its parents, Article 8 in relation to the child's right to an identity, and finally Article 20 subsection 3 talks about the child's right to ethnic, religious, cultural and linguistic background being protected. They all must be looked at in tandem to ensure that all possible efforts are there to serve the best interests of children. Also, the CRC in particular recognises that inter-country adoption should only ever be used as a measure of last resort. On the other hand, I suppose it's important to be aware of the fact that the 1993 Hague Convention further developed the issue of adoption at international level in terms of providing a specific legal framework for inter-country adoption. I suppose the Hague Convention has been criticised of late. It has been, I suppose, while recognised as a deliberated response to the chaotic, corruptive and abusive practices endemic to pre-Hague inter-country adoptions, it is something that has been termed the vague Hague, because the standards set out within it have proved to be very, I suppose, lacking in terms of detail. That said, it does enshrine the child's best interests at the heart of the inter-country adoption process. Also, it sets out minimum standards in relation to inter-country adoption procedures, and that's designed to eliminate possibilities of child trafficking and baby selling in the future. It also facilitates cooperation between state parties, whether they're sending or receiving countries. While Hague has in some ways failed to, I suppose, meet its primary objectives, it is important to be aware of the fact that, it has, I suppose, served some purposes in the sense that it has, I suppose, an aspirational framework, and it gives something for countries all over the world, and it sets out benchmark standards for countries all over the world to adhere to. In terms of inter-country adoption in Ireland, I suppose this is something that has been developing since the early 90s. Up until 91, Irish law regarding inter-country adoption was largely left unregulated. Following the overthrow of the dictator Ceausescu in Romania in 1989, the plight of many orphans in Romania was publicised in the media in Ireland and all over the world. The communist ruler forced all women to have at least 5 children, and at the same time banned contraception and abortion. And unfortunately, this resulted in tens of thousands of unwanted Romanian children being left in state institutions in Romania. Approximately 30,000 Romanian children were placed for intercountry adoption as a result. And I suppose when this particular issue was highlighted through media reporting, there were an unprecedented number of Irish couples flocked to Romania with the aim of adopting children from orphanages there. So as a result of that, the 1991 adoption legislation was brought in Ireland, designed to regulate the situation to some extent. Ireland, I suppose, isn't new to intercountry adoption in that it developed late as a receiving country, but it also has had a long history as a sending country. The history of Ireland as a sending country is a very sensitive and controversial topic when considering the multifaceted ethical issues involved in moving a child from one jurisdiction to another. However, it is important to note that Ireland as a receiving country has not been immune from the controversy surrounding some of the more sinister aspects of contemporary intercountry adoption. The relationship, for example, that Ireland had with Vietnam as a popular sending country highlights some of the unethically questionable practices all too often associated with the process. So, for example, some of you may be aware that in 2006 a very serious adoption scandal ruptured Ireland's relationship with Vietnam when it was discovered that a Vietnamese facilitator was involved in coordinating adoptions from from Vietnam to Ireland, and that person had in fact got a criminal record. And I suppose it's unethical and illegal practices like this that, as I say, give intercountry adoption a bad name in some respects. The recent Haiti earthquake, it also highlighted the way in which the adoption system can be seriously abused. In this instance, several countries were accused of trying to encourage the removal of children for adoption, despite the fact that the legal process had not been completed. Even more recently, China, a sending country usually associated with ethical and transparent intercountry adoptions, was highlighted as a country operating very corrupt adoption practices. So it's important to remember that although many adoption controversies don't relate directly to Ireland, we cannot close our eyes to the fact that intercountry adoption can and does remain ethically questionable in some respects, despite the existence of legislation to protect children's rights in this context. Intercountry adoption is a global phenomenon now, of which Ireland is a part. There are other limitations to the Hague Convention. For example, there's no reviewing or reporting mechanism at international level, and there are no sanctions for non-compliance. And indeed, ineffective regulation has generated widespread potential for trafficking, kidnapping and baby selling. In terms of reasonable fees, the issue of money has always been a very contentious issue in the context of intercountry adoption. And in fact, money transfers are only meant to cover, in principle, the costs of the procedure, the maintenance, medical expenses, etc. Yet it is important to remember that many individuals who are involved in the intercountry adoption business earn their income from that business. And these jobs exist because of the flow of adoptive children. While international agreements don't permit child trade or baby selling, it does remain a complex issue. In reality, money does exchange hands when adopting a child, and the challenge in making this a more transparent process is not an easy one. In some countries, adopters are asked to make a humanitarian contribution, and the question we would ask is to what amount? The Hague Convention does attempt to address the issue of fees, and in keeping with this, the Adoption Authority of Ireland on its website has stated that the authority will reserve the right to seek evidence by way of documentary proof of the amounts of all such payments. This may require the production by adopters of original invoices for payments and original receipts of payments made. In cases where it becomes apparent to the Adoption Authority that unreasonable levels of costs have been incurred, and or where it appears that undocumented cash transactions have taken place, the authority can reserve the right to refuse to grant an entry into the statutory register of inter-country adoptions in respect of the adoption concerned. Now, while that is an admirable objective, the reality is that if the child in the process, if their name isn't registered on the Register of Inter-Country Adoptions, effectively that child is without a birth certificate within the Irish framework. So it's the child that loses out, despite the fact, that the process has been corrupt in any case. Also, the argument has been made that, I suppose, the fact that the Hague Convention has remained vague on this issue is really with a view to allowing countries and the central authorities flexibility in terms of making definitions of their own. The problem is that countries haven't taken that extra step to put those extra safeguards in place. The other issue is the age of prospective adopters. Despite expressions of concern from many professionals about the age of prospective adopters, the Adoption Act of 2010 has not addressed this issue. Currently, Irish law doesn't impose an upper age limit for international adopters. The assessment is based on certain criteria where applicants must meet particular standards. So in other words, they must be of good moral character, of good health, and they have a reasonable expectation of being capable of looking after the child throughout their childhood. So again, that section of the Act is vague and it's open to interpretation. And I suppose it leaves the age issue fraught with uncertainty since the wording is so general. And where a couple have been deemed ineligible to adopt based on age in Ireland, where the age is generally around 37 as an upper age limit in terms of domestic adoption, that doesn't close off the possibility for those individuals adopting a child from abroad. So there are anomalies within the Irish system itself. Finally, the other limitation is in respect of same-sex adoptions. Again, this is something that warrants discussion. Since the Hague Convention is based on cooperation between two countries facilitating the adoption of a child, in practice the eligibility criteria for a receiving country may not be the same as that for a country of origin. So just to give you an example, in the context of domestic adoption in Ireland, our law does not facilitate same-sex couples adopting a child jointly. Okay? In England, however, civil partners can adopt a child jointly. And I suppose even within the Irish framework itself, a single person who is in a same-sex relationship can adopt, and they will be assessed with their partners, but they will not be able to adopt jointly. The difficulty with that is that aside from the parents' rights, the child loses out, in the sense that the child doesn't have necessarily any inheritance rights in respect of the the non-adoptive parent. So I suppose in the context of a system where the best interests of the child are supposed to be central, these are examples of the best interests of the child being lost sight of, and I think that's very, very important. Also, I suppose the argument can be made that in denying same-sex couples the opportunity to adopt, that is clearly feeding into a system that is clearly militating against the rights and best interests of children. Because the reality is that it's happening in practice anyway, but the law isn't addressing that situation. So just in terms of some observations and conclusions in that, Ireland is clearly now finding itself in uncharted territory. It's entering a very challenging period during its initial years of implementation of the Hague Convention on Inter-Country Adoption. The fact that Ireland has ratified the Hague Convention is clearly a step in the right direction, and the fact that it's incorporated within the domestic framework. It's widely welcomed, it sets benchmark standards of protection, and I suppose, it gives us something to build upon, but that's the point. It's really only a starting point. It is absolutely imperative that not only Ireland, but other state parties put in place further safeguards for the best interests of children to be protected. It is also important that, given the experiences of other jurisdictions, in terms of the difficulties with the inter-country adoption process, it is imperative that Ireland pays heed to the experiences of those countries when it's working in accordance with the Hague regime. I suppose the final point I want to make is that really it's all well and good having these international agreements and the international agreements incorporated within the domestic legal framework. But the reality is that international agreements are only as good as their enforcement mechanisms. And until we, I suppose, develop further safeguards on the ground, and in terms of providing consistency for all states to the Convention, in terms of providing more rigorous safeguards in relation to the best interests of children, really it's important, the best interests of children will be lost sight of until they're actually put first. And I think, that leaves us with, thoughts in terms of, and reflections in terms of going forward, what we're going to do to make the system the best it can possibly be in terms of enshrining the rights of children and the best interests of children in terms of inter-country adoption. Thank you.